In a country where the CBI is considered a veritable arm of the ruling dispensation, the Central Bureau of Investigation today took a contrary view. But a view that many say benefits the Union Home Minister, P. Chidambaram. In another twist, another major twist to the 2G case, the JPC today summoned the Union Finance Secretary and asked all ministries concerned, including the Prime Minister's office, to file an affidavit on documents submitted so far. The JPC extremely miffed at Finance Ministry's 25th March 2011 note not submitted to it. And this brings me to my first face-off question of the day. Did the government hide facts in the 2G case? Joining me on center stage, Dr. Subramanian Swamy, President Janata Party. With me in the studio, also Sushil Kumar, Senior Advocate, Supreme Court, A. Raja's lawyer, Nirmala Sitharaman, defending the BJP, and Vinod Sharma, political editor, The Hindustan Times. Nirmala Sitharaman, is the government hiding facts from the JPC?
Well, at least in the JPC, there seems to have been a big furore on the fact that this particular note, which has now created a very big turmoil in the country, has not certainly been given. So to that extent, probably that document not being produced in the JPC is sort of an indication that the government is probably not revealing it all. And even this document, as obtained and which later subsequently has been produced in the court, has been obtained through the RTI. So somewhere, all of us are under the impression, which of course as a political party I can voice, clearly the Congress party has taken the same typical stereotyped route. Okay, you are part of a corruption and then you deny it, later you cover it up. Okay. And after that you come and say, no, we are responding to the court.
Dr. Subramanian Swamy
is perfectly fitting even in this case.
Dr. Subramanian Swamy, you're a crusader in this case. That's the way the perception is. You also get this impression the government not coming out with facts, it's only through RTI or through your sources that things are coming out?
Oh, I agree with Sitharaman that this government has now a certain modus operandi which involves in fudging the facts. You see, I have produced before Supreme Court such amount of documentation that the CBI now is in a terrific state that if the court orders an investigation, people will say, if Swamy can get these documents, how come the CBI didn't get it? Was it suppressing it? Obviously it was suppressing it. So there is no doubt that they have much to lose and they are going to suppress all 2G information.
Okay. Mr. Sushil Kumar, this is the case that you made out in Supreme Court. 1,35,000 documents you say that are there. Only 80,000 put out in public domain by the government.
Yes, because CBI is suppressing more than 50,000 pages, which will have vital information, either for the innocence of my client or implicating many other people. So for whatever reason, they are not supplying it to the court or to us. I have asked for a specific file, because Dr. Swamy read out a document today in court, which I fully support, because the allegation there is that there was a meeting of the Prime Minister and the Finance Minister as well as the Communication Minister where the decision was taken that transfer of equity or dilution of equity is not sale of license. That is one of the basic features of this case. But this file, which is numbered here, has been suppressed by the CBI from the CBI court itself. It is with them for the last 2 years. I have been asking for it. I raised it even in the Supreme Court that why don't they give us, how do we defend ourselves? But just it was not noticed properly, I think.
Okay. Vinod Sharma, this is not only bad in law, this is also bad politics if true, if CBI is, if the Congress party or the government, they're hiding facts and they're suppressing things from court, from JPC.
Well, about the court, I wouldn't know much because Mr. Sushil Kumar is there, and Dr. Swamy is there. But it's over as the 2G note not being presented before the JPC, I'm quite surprised. Because my information is that this notes were actually prepared to take a agreed position before these authorities, the JPC and the PAC. So as to why this note has not gone to the JPC, I'm quite surprised. And is it because of certain observations that are now part of that note, which were not supposed to be there, because actually meant to be a fact sheet or a background paper? I think that in the JPC, the government will have to face a lot of heat and they'll have to be accountable to JPC because JPC is mini parliament. And they can't be taking the parliament for a ride, especially when there is a huge tussle going on today about the supremacy of Parliament, about the credibility of the political leadership, regardless of what hue it comes from.
Okay, this is extremely serious. Sitaram Yechuri went to the extent of saying it's a breach of privilege. It's a very serious act.
It is a breach of privilege. Let me say on your channel for the first time that this office memorandum, it's not a note. Note is a wrong description. Note is a very ordinary thing. In government terminology, office memorandum is part of the official record. Office memorandum is nothing compared to another note which has been suppressed, which I will produce perhaps in the trial court, written by one Miss Kuller, now Secretary, I think, of Sports.
Okay.
And she produced a voluminous document, completely documented, where she pointed out that not having an auction was a great tragedy for the Indian system, and it went all the way to the Prime Minister's office. So when that comes out, I think all hell will break loose.
It indeed will, but is this as far as P. Chidambaram is concerned, now Home Minister, then Finance Minister, is this an act of omission or is this a criminal breach?
It is a criminal suppression of documentation which will attract several provisions of the IPC, including 193 and perhaps 467, 468 too. And I think the government is in a Watergate kind of situation. The more they suppress, the more they are in trouble.
Okay, is that what is happening? Is this India's Watergate?
More surprising is the fact, I mean, Dr. Swamy has his right to his own imagery. I may not share that, but what surprised me more was that this document has been given out to an RTI activist and has not been given to the JPC. How do you justify this? Surely one hand of the government doesn't know what the other hand is doing, and they are in the, at least on the 2G issue, are increasingly coming across like a waist belt without a buckle.
No, but
and that's why they're not able to hold it out.
Not knowing what the other is doing, or is this a feud within the government, and that's why this entire case is now
unraveling? Let me tell you one thing. The 2G issue, this is my very subjective assessment, and you can contest it, you can debate it. This 2G note, or as Office Memorandum Dr. Swamy says, is not reflective of the battle that has happened in the past between Mr. Mukherjee and Mr. Chidambaram, many issues, including the 40% increase in the prices for above poverty line people, then Mr. Chidambaram saying that the finance minister was not doing enough to curb inflation. And then finally this whole issue of alleged tapping and all that. There have been differences of opinion between the two, but this is not a reflection of that. This is my very subjective view. You can contest it, but this is my reading from what I gathered.
I agree with you. Okay. Because I think this note was asked for by the Prime Minister through the Cabinet Secretary in order to prepare himself for Parliament. And it was not for being read out in Parliament, but not for him to step on any mines, or tell something which turns out to be false. So he wanted a complete factual report.
And many meetings were held, all chaired by the Cabinet Secretary. And this, because the Finance Ministry is the nodal ministry, it's like you planning your news coverage on a big event, and the coverage plan coming out of the output editor's desk, and if there's something wrong goes, all of you are responsible,
Okay,
not just one person.
In a case like this note, this 25th March 2011 note, Nirmala Sitharaman, was meant to save the Prime Minister from stepping on any mines, but this is proving to be perhaps the biggest minefield for the government today.
Well, we've been repeatedly saying that what is seen in the note is a very graphic picture of what is already in the public domain. And based on all of that, we've been questioning three vital things on which till today the government, neither the FM of then or the PM have not answered. They both have not answered. And they are the three critical issues. How could you sell in 2008 in 2001 price? Why did you change your position between 2007 November and 2008 January? You have not explained it. Your ministry was completely against you supporting this going for first come first serve basis. But defying his own ministerial advice, how did the minister support, for whatever reason, this going in for first come first serve? Second, and also to suggest to the Prime Minister, treat it as closed. And above all, I think at that stage, it was still letter of intent only. If his interest was to genuinely take care of the interests of the country, he should have stopped it at that stage and said, sorry, we are not allowing the spectrum distribution.
In fact, the license condition, section 5.3 of the UASL license condition provides for public interest to be a factor for cancelling the license. Second is, under transaction of business rules, he could have asked for a cabinet meeting, because when two ministers disagree, there can be a cabinet meeting.
Well, do they disagree, or as you've said that Mr. Chidambaram appears to be the senior partner in this, and Vinod
There
Sharma.
was no disagreement.
Okay, Vinod Sharma. No, I am just quoting what Dr. Subramanian Swamy said, and which brings me to this point. Now that Prime Minister is returning, isn't Congress keeping silent on this actually harming the party and the government's interest?
Having already harmed the country.
Having harmed the country.
Well, I'm caught between Sita and Dr. Swamy. But may I say that, I have a different take on this.
Okay.
I hope Dr. Swamy will bear with me, and so will you. That look, this was a decision which was taken by the then finance minister, and he went along with Mr. Raja's assessment. Now, you see, assessment or whatever, but it was a policy decision. It was a policy decision. But today, if you look at that policy, that policy, if you were to charge more for 3G, like 3G, what has 3G done to the telecom sector?
Okay,
you must hold the program on that.
I think we'll debate that on another program, but let me bring in Abhishek Manu Singhvi, the Congress Party national spokesperson, who joins me now. Abhishek Manu Singhvi, did the government hide facts from the JPC? The JPC extremely miffed today not having that March 25th, 2011 note, sir.
I can certainly not answer that question, and I'm not entitled to, nor am I equipped to do so. Let me tell you that suppression or hiding things like that from Parliament or from parliamentary committees is a serious thing, and you can rest assured, first of all, that no government takes it lightly. Secondly, that the JPC is fully armed with all powers to make sure that if that has happened, proper consequences will flow. So, I don't think it's important to react to just reports like that. I don't think there's any basis on that allegation unless and until something concrete is found, and the JPC will take care of it. But there's no question of the Congress party getting into it. The stand of the Congress party is that of the government, that there has been no suppression.
If there is no suppression, why is it that this is not the only note? There are allegations that there are several other documents that are not being put in public domain. In fact, Sushil Kumar, who's representing A. Raja in court, said out of 1,35,000 documents, only 80,000 are being put out in public domain, sir.
I think this is the kind of comment which shows unfamiliarity with the proceedings of a parliamentary committee. There are loads and loads of documents. Now, the fact that some documents are or are not produced does not indicate that if they are not produced, they're being suppressed. People bring documents according to their understanding of relevance. Certainly, in the course of discussion, if certain documents which are not there are still found to be relevant, the JPC or indeed any parliamentary committee asks for them, and they are again brought. And a third time and a fourth time. It doesn't mean that out of a mass of in fact, precisely because there is 1,35,000 documents, if that figure is correct, and I'm not accepting that figure absolutely, precisely because of the large number of documents, it's obvious that all of them are not produced at the same time. But that doesn't mean they are being suppressed. Okay. I'm sure the committee, whenever it pointedly asks for something, it is produced.
Okay. The minutes of the meeting that took place where P. Chidambaram and A. Raja were there together, A. Raja's counsel makes the point that these minutes show that his client did not take any unilateral decision, that it was concurred by then Finance Minister. Again, these documents, his allegation is the CBI is not putting out these documents in public domain, even though the CBI has these documents, sir.
Gaurav, let's be a little careful here. To react daily in the evening to what a counsel argues on behalf of an accused in a criminal trial, for that matter, any criminal trial, and much more so in a high-profile case like the 2G, and then to base allegations on those arguments is going to be very, very weird, I would say. It's just not done. A counsel for an accused in court can, does, and can intend to argue anything. It does not mean that his arguments are the basis of culpability of other persons not yet arraigned as accused. It is precisely this job which the investigating agency, and in particular the investigating officer of the CBI, has to do before the arguments of the charges start. It is of course possible that in the middle of arguments on a charge, as Mr. Sushil Kumar is doing for Mr. Raja, some startling new thing comes, in which case the magistrate is always entitled to call for an additional accused and for asking for the statement. But this is a dialectics between the counsel for the accused and the magistrate, and at most the CBI. There's no question of yours straight away drawing an inference because Mr. Sushil Kumar asked this question, therefore please include so-and-so as an accused.
No, look at it this way. Mr. Raja was a cabinet colleague till before this thing came to the court. He's been saying then and he's saying now, and he's been consistently maintaining that every decision that he has taken has been taken keeping the finance minister and the PM in the loop. And now, just because he's now subject to the court and the interrogation and he's held in the prison, to suddenly disown him. I'm not saying the Congress party should speak this way or that way.
Okay.
Till now, they were saying it was all the alliance party.
Let me answer that.
Today, it seems to be, when it is reaching their own doorstep, they're disowning a colleague with whom that party is still in alliance with them. It's amazing the kind of distancing that they can do on this matter.
Okay, let me put this question to others on the program. Let me get Subramanian Swamy. Sir, you were inside court today. The CBI, K.K. Venugopal and P.P. Rao, they took a completely different line. Now, is this a carefully orchestrated strategy or no?
No, it's not. It cannot be, because the CBI has a problem. They have been in denial that there is anything substantive on record which will change their old stand that nobody except Raja is responsible for this crime. Now, I have brought a whole lot of material, and the principal offences listed in the FIR are 2001 price and the share dilution to Etisalat and Telenor. On both counts, the record shows that Mr. Chidambaram was a party to the decision. In fact, Mr. Chidambaram has written one letter to Raja saying, let's come to an understanding and then both of us will go and apprise the Prime Minister. So that's 21st April 2008 letter. Now, suddenly the CBI will be asked by everybody, did you not know about these documents all this time? You are suppressing it, as a friend here has been saying. So therefore, the CBI is fighting hard to see that the court doesn't order a court-monitored investigation into Mr. Chidambaram.
Okay. Mr. Sushil Kumar, your point all along has been probe Chidambaram, bring him to court, let him be a witness. Now, there's been a complete volte-face from you in court.
No.
Now you're saying, you
have misunderstood.
No, but
you
isn't
give
your
a chance
case
to speak then?
That let Kanimori and A. Raja get bail and let whatever happen?
Like example given, please understand my argument. My argument is today the union says you cannot monitor because charge sheet is filed. Charge sheet was filed on 2nd April, 6 months back. Till now it didn't suit them to take the stand. Today, because somebody is pointing fingers at the then finance minister, the government says don't monitor. That is my argument.
Okay.
Now we don't know whether you are monitoring or not monitoring. The people are rotting in jail because you say come to us for bail only after charge is framed. Charge can't be framed because investigation is on. So we are in circles. That is what I said. Not that I have taken a U-turn.
Okay.
Still I will apply to the trial court to call Mr. Chidambaram under section 311 as a first witness, so that he can spill the beans and the fire will reach the main person. You don't know what the strategy about the legal process is.
Okay.
First person will be Chidambaram under 311. He may have his own application in his own case, but my case is separate.
That's right.
And in your case, you still want Chidambaram to be a witness?
Because without him, there can be no complete picture before the public.
311 is a very serious one.
It indeed is. And should the apex court, as the government is praying, the government prayer is that the Supreme Court should stop monitoring the probe. Now, should the court stop monitoring it?
No, because the judgments they gave, unfortunately, something they have been doing against Narendra Modi has backfired on them. The latest judgment of 2011, two judgments, now say that even if the charge sheet is filed, if an application is made including by the CBI, the court may consider it. Okay. Now, so they have sort of relaxed that old stand that once the charge sheet is filed, then you don't have to, then the court monitoring must end. So that's the problem the government is facing.
What should the government strategy be, or what, you're a fly on the wall when it comes to what's happening in the Congress party and the government. What is the government actually planning to do once the Prime Minister is back?
Well, to be honest to you, if they were good at planning, they wouldn't have been in this dire state, to be honest, So I think that the government, the least they can do is to put their act together. The Prime Minister shall be back tonight from the United Nations, and thereafter I think they'll have a closed-door meeting where they'll decide their strategy. But quite surely, on the 2G note, I insist on calling it a note, they will have to be accountable to JPC, they will have to be accountable to PAC. I do not know whether it will come up in Supreme Court and in what way. These two gentlemen know it better, but they will have to answer that before the Supreme Court as well, if it is made part of the material before the court or lower court.
Okay.
But on the Narendra Modi thing, as Dr. Swamy was mentioning.
Can I just ask you one more question on this issue? They'll tell me what's happening in the Supreme Court. What happened in Sonia Gandhi's court? Both the ministers went there yesterday.
You see, nobody knows about it. If anybody claims...
Nobody knows whether she was met or
not. But if anybody claims that he knows about what transpired, then he's making a bogus claim.
Including whether Sonia Gandhi was there.
No.
But have they finally buried the hatchet?
No, that you can find out from Mr. T.R. Balu, who went and met.
Yes, I did.
Correct. No,
I did.
So what did he say?
Well, he said some terrible things. I don't want to quote it.
Okay.
No, but anyway. I really want to draw your attention to this. It is no longer a matter of the UPA chairperson trying to sort to ministers, senior ministers, differences between them and things like that. This is a matter of serious concern. Major violations have happened. Terrific loss has taken place. It's all out of the streets. People have, even one election in Tamil Nadu has been completely, if you think, fought on this ground, on what extent of corruption has happened, and therefore DMK has been sent out. Okay. Now, if the country has to just wait and watch as to what is going to be the ironing out of differences, I think we are really doing a disservice to this country. It doesn't matter to us whether the UPA chairperson is sorting the difference between two senior ministers or not. What exactly is the reason for selling spectrum, which is a scarce resource like this? And in this fashion, until today, no responsible person from the government has answered any of the questions. It's very, very convenient to say. Of course, it's convenient to say what's been happening.
She's within her rights. She's from the opposition.
Oh, thank you.
Opposition has to make that point. You are within your rights. I'm not seeking any thanks from you.
No, but matter of fact, I think the government owes an answer.
You see, but one thing is very clear, that the court is seized of the issue. The judgment will come from the court. The nation is waiting a judgment from the Supreme Court or from the lower court, not from the BJP. Please, this is also very clear. And if that is so, then we must have to go back to the start of spectrum, where how it was allocated during the NDA time, and the two lawyers are sitting here, and they shall be equally accountable, that how certain people who today have surplus spectrum got it free of cost. Who gave it to them?
This is what has got to go to the court. But what has got to be said in the parliament has not been said. And today you notice that the JPC also saying that what has got to be in the court will be in the court. But on those matters of policy, procedure, checks and balances, all being shattered by the government.
What's your strategy?
Where are the papers?
Well, I'm waiting for the order, because it's only Mr. Prashant Bhushan who has the main matter, which is about the monitoring.
But should that be a Supreme Court? Should that be an SIT? He's asking for an SIT.
Well, I think an SIT, because the behavior of the CBI might force the court to appoint an SIT, because the CBI has not functioned anymore because of the Chidambaram matter as a body which is interested in investigation. Okay, in this matter, the CBI definitely looks as having truncated the investigation, suppressed the information, and tried to protect Mr. Chidambaram.
Okay. Would you also be of the opinion that an SIT would probe better than the CBI?
I'm not on the agency, but in 2009 when they examined their first witness, the name of Mr. Chidambaram and the Prime Minister came up in the statement of a witness, who is the first witness examined. The next step would have been to go and examine Mr. Chidambaram under section 161 and then see what happens. But that was never done for the last 1 year.
Okay, the matter in the apex court does come up tomorrow. Prashant Bhushan, senior advocate, arguing for an SIT to be formed on this case. We're tracking developments on the story very, very closely. But for the moment, Dr. Subramanian Swamy, Mr. Sushil Kumar, Nirmala Sitharaman and Vinod Sharma, and of course Abhishek Manu Singhvi, many thanks for joining me here on Center Stage.